This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why there is no use of Respondeat Superior for an impaired driver who is doing things that have nothing to do with his employment. And an intoxicated driving is not in the course and scope of an employment of a manager of a pizzeria. In Gerard Loftus et al. Versus Three Palms Crocker Park LLC, a decision of the Court of Appeals of Ohio, made on March 23, 2023, an intoxicated person who injures a passenger when he lost control of a vehicle at 120 miles per hour and crashed, seeking coverage from a CGL insurer of the intoxicated driver's employer. Robert Sotka appealed the trial court's grant of summary judgment in favor of his employer, Three Palms Crocker Park LLC, and its insurer, State Mutual Auto Insurance Company. Plaintiff Loftus was severely injured as a passenger in a single-car accident which Sotka was driver of the vehicle. Sotka was the manager at the Three Palms Pizzeria restaurant and had discussions with Loftus about potentially purchasing a restaurant with him. Sotka left the restaurant at 5:15 p.m. and traveled over 60 miles to the Canoe Club to meet Loftus and a group of Loftus's friends. At around 10:15, Sotka was driving, exceeding a speed of 120 miles per hour, when the car left the road and hit a guardrail, causing extensive damage. Sotka's passenger, Loftus, suffered extensive and permanent injuries. Sotka was later convicted of the crimes of operating a vehicle under the influence of alcohol or drugs, a misdemeanor of the first degree, and vehicular assault, a felony of the fourth degree, in the Ottawa County Court of Common Pleas. Loftus eventually sued Sotka and Three Palms, Sotka's employer. State Auto, who had issued Three Palms a business insurance policy, intervened in the lawsuit and sought a declaratory judgment action that it need not provide a defense or coverage because the accident that resulted in Loftus's injuries was not covered by the insurance policy because Sotka was not conducting or furthering its business when he crashed his car, injuring Loftus. The trial court granted summary judgment to both Three Palms and State Auto, and of course, Mr. Loftus appealed. An employer, of course, may be subject to Respondeat Superior liability for an employee's accident when the employee is acting within the scope of employment. Conduct is within the scope of a servant's employment if it is of the kind which he is employed to perform, occurs substantially within the authorized limits of time and space, and is actuated, at least in part, by a purpose to serve the employer. State Auto's insurance policy provides liability coverage to Three Palms pursuant to a CGL policy, and the parties agreed that the CGL policy specifically excluded damages for motor vehicle accidents pursuant to an exclusion. The auto endorsement provides CGL coverage for damages arising out of the use of any non-owned auto in the business by any person. There was no dispute that Sotka was driving a non-owned auto as defined by the auto endorsement. However, the auto endorsement only provides coverage while the non-owned auto is being used in Three Palms' business. The trial court determined that neither condition was present upon the record and specifically found that there was no genuine issues of material fact that Defendant Sotka was not within the course and scope of his employment with Defendant Three Palms. At the time of the subject accident, the court noted that Sotka left the restaurant at 5:15 p.m., traveled a distance of over 60 miles, and admitted the purpose of his trip was to meet with his friend and soon-to-be a business partner. There was no evidence Sotka went to Catawba for any business purpose to benefit Three Palms. Traveling 60 miles and socializing to pursue personal business unrelated to his employer cannot reasonably be deemed to be in the service of Three Palms. Considering Sotka's conduct in total, assuming he contacted employees and spoke with others about the general aspects of the operation of a restaurant, those actions were merely incidental to the purpose of his evening, socializing with Loftus and furthering a personal business venture. Moreover, the restaurant employees present on the evening of the accident closed the pizzeria restaurant without Sotka's direction or input. The record reflected that Sotka's purpose in going to Catawba that evening was to socialize and further his own personal business opportunities, arguing that the accident occurred while Sotka was acting within the scope of his employment or in furtherance of Three Palms business was unbelievable and difficult, if ever, to consider. Sotka committed the offense of operating a vehicle under impairment and vehicular assault, a felony. This conduct cannot fairly or reasonably be deemed to be an ordinary and natural incident or a tribute of the services to be rendered, or a natural, direct, or logical result of it, his services as an employee of the restaurant and pizzeria. In my opinion, the Ohio court concluded, as only a reasonable person could conclude, that a person, after spending an evening drinking and reviewing potential opportunities to obtain a new and personal business with an acquaintance, and then while intoxicated, starting a return ride to home at more than 120 miles per hour to take his acquaintance either to his acquaintance's home or to a restaurant owned by Sotka's employer, was simply outside the scope of that employment. Sotka was convicted of a felony as a result of his driving and the injuries to the plaintiff. The conduct was obviously not part of Sotka's employment as the manager of a pizzeria, and therefore no coverage from the employer or the employer's insurer was available, nor should it have been. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and will receive emails advising you of every blog posting, usually 5 a week, sometimes 6. And you can also subscribe to the videos at rumble.com or at youtube.com. And if you view these videos, please click on the like button at YouTube or the Rumble button at Rumble. And if you found this blog and these videos to be of interest and use to you, please tell your friends and colleagues so that they can also subscribe to the blog and to the videos. Thank you for your attention.